Good morning. Welcome everyone to the New Hampshire Realtors Fall Broker Forum. My name is Susan Cole, the 2025 NHAR President, and I'm happy to be joined in studio by NHAR Legal Counsel Matt Johnson and virtually by our guest today, OPLC Executive Director Dee Jurius. We're planning to start with a few questions for Dee from us at NHAR, and then after 15 to 20 minutes or so, we'll open it up to you, our New Hampshire brokers. Please send additional questions to our CEO, Bob Quinn. That's Bob at NHAR.com, and he will follow up with Dee and get back to you. Let's get into our questions now, and thank you again, Dee, for joining us. Could you describe the roles of the OPLC versus those of the Real Estate Commission?
Hey, good morning, everybody. I'll just start by saying hello. So you asked specifically the differentiation, the role of the office versus the board, the Real Estate Commission. Is that the?
Yes, that was first question.
Absolutely. Happy to speak to that. So, as has been the case for several years now, and we're fully fleshing that out, the board is responsible for promulgating rules, for criteria for licenses. For all the license types, they have a statutory authority, to regulate. And then they're responsible for the findings of fact in disciplinary cases and then deciding whether to move forward with those cases as well. So it's really a twofold. To really boil it down, it's quite expansive. If any of you have been following along with the commission's meetings, you know how hard they've been working on rules. It is quite a monumental task. But it's making rules, criteria for licensure, and findings of fact in disciplinary proceedings. So the real meat of it. The office is responsible for moving the paper around. So it's receiving the complaints, it's receiving applications, making sure that everybody has checked all of the boxes, and then issuing those credentials. So the real substance for the Real Estate Commission and most of the other boards that are under OPLC are the ones that are responsible for kind of those policy pieces, the criteria, and then the office is the one that does the processing there.
Okay, thank you. Can you quickly review the requirements for licensees in using CE Broker to track continuing education courses? Also, this question is three parts. What happens if an agent fails to upload their courses? And third, if brokers have questions about CE Broker, who can they contact?
Yeah, absolutely. Okay, so the first one, requirements for using CE Broker. So there is a rule in the PLC rule. Again, OPLC is responsible for the process of it, right? So the commission decides what continuing ed is required for each profession, and then the office does the processing of that. So there is a rule that requires the use of an approved online system. The name of the vendor who's currently doing that work is called CE Broker. So there's a requirement to log that. The way that the office keeps track of that is on a renewal application, right? Because all of the continuing ed is linked to that 2-year renewal cycle. And I know your commission has some specifics as well within that first renewal. So there's some nuance there that's separate from other boards. It's an attestation. I have completed the CEs and documented it as required, and I don't have the exact language on the application. So an applicant in their renewal would say, yes, I have done that. And then that is submitted as affirmative. I like to say our whole system is based on when you tell me something, I believe you, right? So if you tell me you did it, we believe that you did it and can move forward in that way. The hope is as more and more people are renewing and attesting that they've used it, they are using the system and will have enough critical mass to perform what we have set in rule and has been a longstanding practice of many boards to do continuing education audits, which means that they would take a small percentage of a set of renewals. And CE Broker, the company, has a way to basically just export that information and we can verify, yes, they did the required courses. And so that's the primary function of having that external is they track all of that and help with an audit. So the requirement is set in PLC rule. If they fail to upload their courses, and so if somebody didn't do what they were required to do, but attested that they did, there could potentially be implications for that. You would be saying you did something you didn't do. So you should just do it if you're going to attest that you did. If you don't do it, then you would not be able to renew. We have had a few instances where there's been technological challenges that have been like extenuating circumstances, even working with CE broker and with the office. They have not been able to get the course in the right way. And we were able to make something work for them. But generally, the application requires that you attest that you've done it. So if you fail to upload, then you would not be able to renew. And then the last piece of it is if you have questions, depending on what it is, our office, you guys all know OPLC licensing 2 at oplc.nh.gov is the ticket there. But then if it's specific to the technical piece, CE broker on their website, and I know that we have links to all of this on our website, has a ticket for support as well there. So I think I covered all three parts.
You did. Thank you.
Yep.
Prior to your arrival as executive director, the OPLC determined that a salesperson license would stay with that salesperson as opposed to it hanging with their broker. In the past, a broker would be notified when a salesperson plans to transfer to a new brokerage. Can you explain the reason for OPLC's decision?
So I think I'm going to provide a response. I'm not sure it's going to answer the whole question because I'm not totally sure what it's getting at. But a person who has a salesperson's license, it's their license, they own it. So they have the obligation to maintain it. So in terms of hanging with a broker, they're still required to be affiliated with a broker to practice, and there is still an active restricted status, so they would not be able to work without being affiliated. So there is still a connection there. And then not notifying a broker if a salesperson changes. Well, I'm pretty sure the form that is it requires the signature of the broker. So I don't think that to disaffiliate, we would need the signature of the broker and then to affiliate it. So I think a broker should know because I believe they're signing the affiliation form.
Okay. Our last question, can you run through the process for filing a complaint? How quickly are you able to determine if there is the potential legitimate violation or if it will be dismissed? Are both parties contacted? There had been a backlog of cases at OPLC. How close are you to clearing out that backlog?
Okay, so process for filing a complaint. On the OPLC website, on the enforcement tab, there is a submit a complaint section. We have recently updated, if you have not been on in a while, which, I mean, obviously none of us ever hope to be filing complaints, but if you have not been on in a while, we've been providing a lot of updates. There's a pretty lengthy process. It talks about all of the standard procedure. There are FAQs, what needs to be included in a complaint. There's a letter from the enforcement director that's really informative. So I will direct you there for the specifics. But filing a complaint there is the way to start. It comes into our office. I want to state here because it's been, we've received some outreach from different people concerned that a complaint, once it's sent to us, just stays in submitted or reviewed status forever. So I'll just say here, the system that we use, it's called an N form, where you submit it, it's encrypted, it's secure, it's one of the state's secure ways that we can get information. Comes into our office, but it is not a complaint management system, so that status will not change. So if you have filed a complaint and you go back in and you're like, oh, I'm going to check the status, we do not have the ability to do it there. We're building a new enforcement backend portal, hopefully sometime in the next year, that would have some of that available to complainants. But I just want to say really clearly, it's completely that system where the complaint comes in is not a tracking system. So that status, once it's submitted, will not change. So I know you didn't ask that, but we've heard it from a few people. So I just wanted to clarify it's totally separate from our back end processing system where it's manually entered. So that's the first thing. How quickly are we able to determine that? So you kind of in the question said, when a complaint comes in, the office says, is this legally viable or not? If it does, and that means if the conduct were true, so we assume whatever somebody tells us is true. If this is true, does it break a law or a rule? Yes or no? If the answer is no, we document that and send it. It is typically at the next board meeting for new incoming complaints. Now, the timing on that, right? If it's the day before or even 3 days before a meeting, it may not make it down. But that is in pretty short order. If it said, hey, there's really no violation of law or rule, that is going to the board quite quickly presently. The board may decide not to dismiss that case. They may say we need to investigate, then that's obviously going to take a little bit longer. But that initial determination is very quick, that those are reviewed on a weekly basis. And then obviously there's other processes that are there. So that's the quickly, are both parties contacted? If a case is dismissed without investigation, the complainant is notified that the case was dismissed, and a licensee would not be notified. So if there was no if it was determined that it was not legally viable is the terminology that we use, the complainant would be notified that it was dismissed and the licensee would not. If there is a potential violation, then both parties are contacted at that point. A licensee and the complainant would have an opportunity to weigh in and be part of that investigation. So, help me out, Susan. I think I'm missing part of it.
The last part was there had been a backlog of cases at OPLC. How close are you to clearing out that backlog?
Oh, yes. So about this time last year, I was having a conversation, I believe, with this group. Maybe we were in person. Does that sound right? Or was it
Yeah. Mm-hmm.
Okay. So not for the commission, but as you know, this is an umbrella organization. So the backlog is less than half of what it was this time last year. We're really very happy about that. And we have conducted a preliminary investigation for every single case that we have. So that means in my office, my enforcement staff did a first review and then did a kind of like a first comb through to go through that backlog, and then a second one where they've conducted a preliminary investigation. So they've touched every case twice. Within that, they've been sorting them into a few different categories. So within the real estate commission, I won't go through all of these numbers, but we have about 100 complaints that are awaiting a response from a licensee. So that would be complaint that we said does need to be investigated. Licensees have a certain amount of time to respond to a complaint. So we'll say, hey, there was a complaint alleged against you. Please respond, and provide us with a written response. And then we have a few others in a variety of different places. Some of them are waiting for a hearing to be scheduled. Some of them are waiting to go on a board agenda. Excuse me. Some of them analysis has been done. Just the memo needs to be drafted. So there's a few different places there, but we are working diligently on the backlog for all of the cases in the office. But real estate is certainly one that cases are actively being worked on in the backlog, but also it's not building, right? So as they come in, they're immediately being triaged, they're being analyzed, and the work is beginning as well. So the backlog is not perpetuating. So we're really happy about not adding to the pile and then slowly working our way through the other ones there.
Great. Thank you for that.
Yeah.
Now what I would like to do is open it up to our brokers. Now is the time to ask your questions, or if you have any follow-ups to the questions that were already answered. Please raise your hand and you'll be called on.
Susan, would you like me to go through the ones in the chat first, and then do the hand? What would you like?
Are there hands raised?
There are hands raised. Yes.
Okay.
Why don't we take one from the hand raised?
Okay. Okay. We'll take some from the hands raised, and then we can go to the chat. How does that sound, Dee?
That sounds great. Whatever you ask me, I will answer, or I will at least take back. Yep.
Great. Okay. Andy Smith.
Okay, thank you. Deanna, you mentioned that after a complaint has been lodged against an agent, the complainant may be or would be notified if there's no further action, but the agent isn't. That just doesn't seem to be one, fair or just. You've got an agent whose livelihood requires this license. They take the complaint very seriously. They respond in a timely manner. Not to let them know that this thing has been dismissed without any findings just doesn't seem the proper way to handle that. Could you address that?
Oh, hi, Andy. Yes, I'm sorry for any confusion. So these complaints are confidential, so the licensee would not know that a complaint was even filed. So it's not there's no pending discipline, that it's not like their license has been revoked. And so if it's determined that there's no basis to move forward and no action is taken, it's dismissed. It's just gone. So there would be no, I wouldn't have any of the concerns, right? The person would not know, in general. So if a licensee is at all contacted, if they're part of the back and forth, right? Like, so if there's any engagement, if there's some investigation and then it's dismissed, then they would be notified. So if there was any action taken, or they would be aware. So I apologize if it sounded like you were like, oh my gosh, a complaint's filed against me, and then I never hear the resolution. That would not be the case. It would not be brought to a complainant if it wasn't legally viable in the first place. So I hope that clears that up.
Thank you. Jeff Brown, please.
Good morning, Ms. Jurius. I did my renewal last year, and I'm kind of a glutton for education classes. I take a bunch of them. And when I wanted to do my uploads on CE Broker, about half the classes I've taken in the last 2-year cycle were not listed. I contacted your office seeking a means for connecting the dots, so to speak.
Mhm.
And I'm wondering, and I made a suggestion, and I don't know if it's been acted upon. That's kind of what I'm interested in. I've made a suggestion that a kind of a master list be created, pairing the Real Estate Commission course number and the CE Broker course number, so that we could go in and relatively easily make the conversion without, let's say there's 30 people in a class, instead of 30 people trying to reach out and contact that instructor to try to get that the CE Broker number for that course, that we could go to a master list and just do the research ourselves. That way the instructors aren't being pestered, you're not being pestered, and there's some ease of making that conversion on our end, so that when we take our certificate and it's got the E number, let's say, that we have the appropriate CE Broker number. So we're trying to file for our renewal, that CE Broker recognizes our classes. Because last year, like I said, about half of my classes weren't recognized. And I'm wondering if that list has been created, and if not, if you have any intention of doing so, to try to make life a little bit easier for all of us. Thank you.
Yeah, thank you. I have a notepad here. I will bring it in my not blurred frame. I'll take that back. So I don't do day-to-day CE Broker communication, but I do have staff that do. So this is the first that I'm hearing of this specific thing, Jeff. But I'm happy to take it back and see if it's been considered, what that has looked like, and provide some follow-up for you.
Okay, thank you. Nate Dickey.
Hi. I missed a little bit about what you said about the notification when licenses change, when agents pull licenses and they don't notify the broker where they're currently hung.
Mhm.
Is there logic behind that? Because it creates a mess. Like,
I'm trying. I'm sorry. I'm sorry. Yep. Go ahead.
And are we looking to maybe change that? It used to be we would have to sign a license, and we had 5 days to sign the license to send it to the state before an agent could take it. We've had several situations where agents have deals with us and have moved, and their license is hung somewhere else, and they're starting to do transactions with someone else because they don't need our signature to remove the license as a broker.
Yep. So I was just, I had just pulled up the form to make sure that I was correct in my understanding. So the office, I do believe there was a time where the office was activating. So we would say deactivate from a broker and then activate with a new broker, right? There was a time where activations were being processed to a new broker without the deactivation from the previous one.
It's not the deactivation. That's less of a problem. The problem is we don't know. Like if I'm responsible for someone's license and
Mm-hmm.
legally responsible for everything that they're doing,
Mm-hmm.
and they can just pull it and it can go somewhere else, and I don't even know about it. Like that's a challenge. So deactivating, great
I'm
that you
sorry.
deactivate, but you don't notify us. We don't even know. Like we used to have to sign off that they were leaving.
Do you mean just pull their entire license?
Yeah, they don't need you used to need the existing broker's signature for an agent to leave to go somewhere else.
Yes. Okay.
So you don't need that anymore. So yes, agents will just go and we don't even know about it until they show up somewhere else.
So
Like there's not.
Oh, I'm sorry,
So-
Nate. So that's what I was just confirming. So, when they're affiliated with so say it's with you, Nate, right? They're affiliated with you and they're like, nope, I'm out. I'm going to go somewhere else. It used to be the case that they could have our office process them affiliating with someone else without getting your signature. Like, as in, there was a practice that, so we would deal with the activation without the deactivation. That is no longer the case. So a principal broker has to sign a deactivation form and the office has to process that first before it would activate to another broker. So it should not be the case that somebody can be with another broker without your signature and being deactivated first.
When did that just start? Because this happened to us like I feel like the other day.
I hope it wasn't the other day. And I know when we all quantify time, it's different things in our head. My clear directive has been you cannot activate with a new person while you are still connected to another broker. And the deactivation needs to be first, and that form requires the signature of a principal broker.
Okay, so it's perhaps my misunderstanding. I feel like this just happened to us when you guys.
It is possible that an error was made or there was processing in the wrong order, but the standard practice is that a broker needs to sign a deactivation, and I have instructed staff not to process an activation until they have done the deactivation.
So everybody on the call heard it. So the rule now is we have to sign again like we used to have to sign before you can pull someone from the roster.
Yes, and I don't know if the rules have ever changed or if it was just practice or if it was just in a customer service, like, hey, we really want people to be able to be working. And if I don't know, but all I know is, yes, you would have to sign because I would understand too. If you're responsible, you want to know where they're going. So,
yeah,
and
cool
I am seeing in the chat, I think we're all on the same page.
Okay, thank you.
Yep.
Great. Thank you for that, Dee. Josh Greenwald, please.
Yes, thank you. Going back to any sort of complaints that are filed with the OPLC, is the managing or principal broker notified of any issue that's arisen with one of their licensees that are assigned with them? If the licensee has been notified that there is a complaint that's been filed and it's an investigation, is the managing or principal broker notified that this is going on?
Can you check with Jen real quick?
Not to my knowledge.
Okay. My personal opinion is that I think they should, being that we're responsible for that agent, and a complaint could easily be turned into some sort of errors and omissions or something a little bit more aggressive in terms that will affect the principal broker. So I would think that, or hope that they would be notified as well, being that they're kind of linked to this entire potential issue. Just my opinion.
I'll make a note of it. It's an interesting thought.
Thank you. Now, if I don't see any other hands raised at the moment, let's transfer or transition to the chat if we could to catch up on those.
Travis has his hand up and Ralph does.
Yeah, we do have a couple more hands now.
Okay. All right. Travis Cole, please.
Hey guys, how you doing?
Hello.
One of the questions I had to do with Nate's question and some further observations there. Who's the ones that decided that when we send a license back, we now have to pay $20 for that? So now when I send a license back to the state, there's a $20 fee for that, for you guys to perform that. There's always been a $20 fee to pick the license back up. I was just wondering who decides that. We used to operate as a commission quite a bit in the black. And I was just wondering why all of a sudden we're adding $20 to these types of fees. And let me tell you my reason behind that. There's a $20 fee there. Sometimes people ask to, maybe they're retiring. So as a company, to run a company, you got to say, geez, who pays this $20? Do I pay it or do I try to pass it on to them? If they're left in a bad circumstance, they're probably not going to pay the $20. So I was just wondering what was the reasoning behind that?
Yes, I think the reality is the processing of a deactivation and an activation is the same. So it costs money to do any of this work, and so it is incurred whether it's deactivating or activating. So that was the decision when the fee structure was looked at.
Yeah, but this just happened recently, so there's
Correct,
something that flagged it. I don't know if maybe somebody picked that ruling up or something, but okay, I appreciate it.
Yep.
Thank you for that.
Yep.
Thank you. Ralph Valentine.
Thank you. Question for Dee. Could you speak to the role of the DOJ and the lawyers regarding all of the boards and commissions? I've got almost 4 years on the commission now, and they seem to be playing a larger role in a lot of decision making, at least at my commission. Thank you.
Hey, Ralph. I can't actually see your camera is black, but I will say it's nice to hear you. Yeah, so role of DOJ and attorneys. So I think there's board counsel, which is an attorney that's in the room for any board, committee, commission who is meeting. Previous to the office's existence, that was the Department of Justice that was providing that counsel to boards. Now it's internal to the office here. But obviously all of us are working for the state, and DOJ is representing the interest of the state. So what that lawyer does is they help interpret the law, let the board or commission know what the law says, what they can and cannot do, and ensure that every applicant or every person who's being disciplined is treated equally under the law, so it's evenly applied every time. So I do hear from a lot of people that they say, what's up with all these attorneys? We do have a lot of laws, right? We have the, if you're making a simple decision in this office, there's 4 or 5 different statutes that govern the office. Then there's a set of rules, and then you have board rules and statutes. So there's a lot of interplay between them all. So attorneys help to make sure that that interpretation is consistent and accurate. And it protects board members, and it protects the state from to reduce legal risk. So in short, I'm not an attorney, but in short, I would say that's a large part of the function.
Okay, thank you. Debbie Ball, please.
Hey, sorry about that. I had a couple of questions. Number one is, I was wondering if there's any way right now when an agent affiliates or renews their license, the agent is the only one that receives a copy of that license. And I didn't know, why that got changed, or if there's any way that when they're emailing the agent the copy that they don't CC the broker, because we don't know when it's come in or not unless we go check on the website or ask the agents repeatedly. I just think that we should be aware once that license has been issued, as well as the agent. That's one question.
Right. I'm making a note. I mean, I think my gut reaction is the agents are responsible for their license, and they need to let you know. But I am making a note to ask the question.
Yeah, no, I appreciate that.
Their license.
Yeah, but we are responsible for them and their licenses. So that's just my question. And then number two is, if there's been a complaint, how are they taking like a really long time? I have agents asking me, what's going on. It's been almost a year since they replied to a complaint, and they haven't heard anything one way or the other. Is there any way for them to check the status of that complaint during this process?
I don't currently have a way to do it, but as I mentioned, we're working on, this agency has been we've been working for a long time. We need to update our legacy system that is old and outdated, and we're actively developing. I actually just got confirmation that the merchant ID for my payment processing specific for the real estate commission just got approved and is in production. And so I would say weeks away from being able to launch that. Weeks or months, like it's in a very short order. With that build out of the licensing portal, we're hoping to build it. We are planning to, and I have money encumbered to build an enforcement portal, which would allow for some more of that public access. I do not currently have the ability to do that.
Okay. And with where was I going with that? With the CE portal, that was another question. I find that sometimes it's very difficult to get in, and even myself, it's telling me I already have an account associated with that license number. Tried resending it. It says it's going to my spam for a certain email address. It's not there. Is there anyone to call? I mean, it's not a very cooperative system, let's put it that way. But anyway.
Yeah, so for that type of issue, certainly would need to reach out to CE Broker directly to help you with that.
Okay.
Yep.
Thank you. Nate Dickey.
Back for round 2, Nate.
Yeah, I am. So this is on Travis's statement. That extra $20, why don't we just make the agents? Why come after us for it? You chase the agents for it.
I don't care who writes me a check. If there's $20 in it, I don't care who it came from.
Oh, that's great. If we can put it on the agent, you guys can bill them when they pull it instead of us. If you bill us,
the check comes in with the form. So I have told staff we don't care where the money comes from as long as it's there and it has your signature.
Okay. So, right. But I can't send it in without it, right?
Correct.
Okay. So they have to send, so we can sign it. Got it. So the responsibility would fall to them. It's Mike. And I agree in the statement that we don't get the licenses. It's cool to say that the agents are responsible for them, but ultimately and legally, like, we're responsible. So we should be notified on anything that happens with the licensee and the license like that. So when they go active, as an agent can be active and you not have anything going on for a month. Then all of a sudden they show up active with this new idea that they're going to be a real estate agent today, and we didn't even know that their license was active. So it is really kind of a pain to find out or to put it on them. Like, if we weren't liable for them, it'd be a whole story. Where we're liable for them, we should be notified equally on the things when they're acting and not acting.
Okay.
Thank you.
Okay, John Doran.
Just unmuting. Thank you. Thank you for being here with us, Deanna.
Hey, John.
Executive Director Jurius.
That's me.
I teach real estate classes, and I had a licensee present a very bizarre question to me recently. They received a complaint, and the complaint apparently has, details required, I think 7, 8, 9 paragraphs. And what she pointed out was that in paragraph or section, I guess you'd say 8, there are supposed to be specific allegations stated along with the specific sections of license law, the sections and subsections of license law that are alleged to have been violated. And she said she was puzzled because section 8 in the complaint was completely blank. What do you do with that?
I will say, okay, so I just want to make sure I have the facts right before I opine. So an agent received a complaint
Licensee.
about a licensee received a complaint about themselves to respond to.
Licensee received the
Okay.
complaint.
Okay.
It was filed by a consumer.
Okay.
And in reviewing the complaint, which is a fairly short form apparently and pretty direct, under due process, it refers to the complainant in this section 8 of the complaint, having to state specifically what the allegations are and make a connection to the sections, subsections of license law that are alleged to have been violated. But
But there was no.
completely blank. And, you know, I couldn't come up with who would you call, who would you make a question to? And this person wanted to do the right thing and get the response in on time. But she said she was quite puzzled to have something with no specific allegations and a brief comment, if you will, or brief explanation, very kind of loose in general, alleging something that had no, you know, reference back in that section to the actual allegation and the alleged violation.
So what I will tell you, twofold. So moving forward, I'm going to make the assumption, I could be wrong. I'm going to make the assumption that this complaint may have been filed in the past. It was not a recent complaint, and it was
Very recent.
It was very recent.
Very recent.
Oh, okay. So typically, what my understanding is, our practice has been, if they don't allege a violation of law or rule, right? We say, hey, you have an alleged violation of law or rule. Thus, we're not going to file this complaint. You know, please, if you'd like to give us an allegation. So, that specific licensee, if they'd like to reach out to the office, to the OPLC enforcement, whoever sent it to to the person, I think it would be very fair to see. I don't see any allegation here in this section. Can you help me understand? Am I missing something? Was it in a different document? Right? I think they would be they would be welcome to reach out to the division on that specific case.
Would there be a non-invested party at the OPLC? For instance, if that person reaches out to the person who, you know, proceeded to allow the complaint to go forward to the respondent, would there be someone who might be not invested in having already, you know, sent it forward that might be counseled?
Honestly, John, I think the person who does the actual sending is a paralegal, right? Like is a person who just says, hey, here you go. Now, they're not the ones doing the analysis, but I think it would be fair for them to just ask the question, be like, hey, I didn't see this here. I don't see an allegation. I'm not sure what to respond to.
Okay.
I think that would be a good start.
So I can suggest to this person who's not on the forum today, unfortunately, because they're not a principal broker. I could suggest to this person, based on what you've indicated, that would be the correct path to follow.
That's what I mean. I don't want to give anyone legal advice, but if they have a question specific to their complaint, because again, it's confidential, it's all non-public,
Yes,
right?
yes,
So but they are welcome to reach out about their own complaint about information that they have.
This is an administrative suggestion.
Yep.
Okay.
Yep.
Thank you.
Thank you.
Okay, we have about 5 minutes left for this topic, so we're going to go through a few of as many of the chat questions as I can. One that popped up: after the CEUs are recorded, what is the process for renewing your broker's license? Do you do this on the CE broker website or the OPLC website?
Yes, thank you for the clarifying question. This is a confusion that occurs from time to time. The CE broker logging is just for continuing education, so the renewal still needs to be processed through the office. And on the renewal application, you would certify that you've completed and logged your continuing ed. So it's through OPLC, the renewal.
Okay. And what is the expected decision timeframe once an agent has responded to a complaint with explanations? Is the REC also backlogged with investigations?
It would be very hard for me to put a specific time frame on it because it would be so case specific, right? So if a complainant responds to a complaint and that sometimes it's the case that responses come back And it's a pretty simple draft report, and that goes right to the board. And the board may say, yep, case is dismissed and it's over. It may be pretty quick. It may be very complex. There might be a lot of records to review. Excuse me. I don't claim to understand fully all of the work that you all do. There's often lots of financial things involved. There can be multiple players. So some of these investigations can be extensive. So I don't know that there's a one size fits all approach, especially if it is in the investigation phase. So I don't think I could say expected time frame. What I can say is we are working to build a system and to provide staffing levels to a point where it is not taking 3 years. That a case would be touched almost immediately and investigation would be going on. And so I don't think it would be a matter of years for the majority or, the vast majority of cases once the backlog is cleared. Is the REC, I guess if you're thinking, does that mean there's a bunch of, cases pending board action? I do not believe there's a backlog. So, if you're trying to say, hey, are we waiting on the commission to take action? Do they have a pile of stuff that they need to deal with? I would say the answer is no. There's a few in process, but it's not as if the office has dumped hundreds of things and the real estate commission is dragging their feet. I would not characterize it that way at all. So
Okay.
the office is holding those. And as we work through them, they go to the board. And the board deals with them pretty expeditiously. They're very good about scheduling hearings. They've even offered to come in more often than once a month. I will give Commissioner Valentine and the board credit. They've offered to say, we'll come in more if you have more cases for us to keep these moving. So they've been great partners.
Good. Okay. Thank you.
Yep.
Next question. Are we required to pay for membership for CE to get compliance status and track CE remaining requirements? Why is our individual progress towards completion or track credentials not available to us without membership? And maybe they mean to CE broker.
I'm thinking that's the case. So CE broker, I have an obligation if I'm requiring this, so there is a free level there, but then you can pay a fee for more. I don't even like higher level of service potentially. So what I want to say up front is you are not required to pay to be in compliance with the rule. So that's the first part. That's important to get compliance status, track remaining requirements. I'm not super familiar with their levels of membership and what is offered for each. I'm going to believe a person who says that tracking is not, that there's a certain level of customization that occurs with a membership, and that the vendor gets to determine that. I will just note if in the future when audits are taking place, so if the office determines randomly that somebody is selected for an audit, they are automatically upgraded to the higher level for that audit to happen at no cost to the licensee. So those additional features are in there if an audit is happening. So there's no need for people to pay for the base level for compliance.
Okay, thank you. One last question, I think, and then we're going to be out of time. I know we didn't get to all of the questions in the chat, but this question, does that deactivation form still apply if a broker opens their own firm?
Meaning, do you have to affiliate with your own firm? That's a pretty technical question. I'm not sure I could opine in this instance. I would say all of you are affiliated with firms. I think if you have I don't have the specifics in front of me. That might even be
Okay, fair enough.
I apologize. Somebody on this call actually may have a better sense of that than I do, but I apologize. I don't have an answer to that question, which is a really unsatisfying way to end our Q&A, but
sorry. I just went down through the line. Anyway, so there's a few more questions that we'll be out of time to get to at the moment for you, but thank you so much for being here, Dee. We greatly appreciate that.
Yes. Thank you so much for having me and your patience with my congested self here. It's nice to see you all again, and I hope you guys have a great fall and a great holiday season. I can't believe we're at Halloween tomorrow.
I know. Feel better, Dee.
All right. Thank you so much. Have a good one, everybody.
Thank you.
Thank you.
Bye-bye.
Okay, now we're going to transition to the sample office policy. We have had one at NHAR for a number of years. It hadn't been updated sort of for maybe the past decade or so. You can find the sample office policy if you go to NHAR.com and you go to the legal header, and then you'll find the sample office policy location there. Matt, could you explain why it's important and why we should have office policies and how what changes happened in that in the sample that is provided at NHAR?
Sure. So the reason to have an office policy is just good firm management so that you have a consistent set of expectations that all of your agents and if you have employees understand the rules of the road and you can treat everybody consistently and fairly. And as people come into your operation, they know what they're given this document and they know what the rules are. As Susan mentioned, we had a policy out there, but it was about 10 years old, and obviously things get change and issues that are important rise to the surface. So we've updated it. It is a document really viewed, it's really a template or like a first start for people. So you can look through the document and there may be provisions or sections that are not really applicable to your business, and there are other ones that are important. I would strongly recommend, though, that if you're going to customize the document in any way or add anything or fold it into anything that you have that is existing, that you do consult with your counsel to make sure there's a proper fit. But there's items about land fraud and issues like that. There is a new section on rules regarding the use of AI. There's a section on social media. So we have tried to update it and address some of the current issues, not just, Fair Housing Act, RESPA issues, those things that have been around for a while. So you'll find it to be more current, and it's a good starting point if you're looking to either update or either create a policy or update one that you have.
Perfect. Thank you. Now we're going to transition to the new laws booklet. Bob, can you update us on that, please?
Hi, everyone. Good morning. This is Bob Quinn. I'm the CEO here at the New Hampshire Association of Realtors. So in addition to the new document with the sample office policy, this past about a month ago, we released the 2025, I don't know if anyone can see this, 25 new laws document as well. So we've had, obviously, it's probably the largest document update that we've had that I can remember. There's a lot of activity that occurred at the State House in 2025. We're certainly not going to go through all of these bills. I think Matt and I will do that at some point in a future date in a different forum. But I do want to, we've received a lot of questions regarding a couple of new bills that I just wanted to chat with Matt about. And the first of that is House Bill 577, which is the accessory dwelling unit bill. So now, prior to the passage of this bill, individuals were allowed to have an attached ADU, unless the municipality allowed a detached, but not all of them did. But the state law mandated that you had to have the right to have an attached ADU. You may have to go and get permission from the planning board to get that permit. This new law, though, is now you're allowed either an attached or a detached by right. So, Matt, what does that mean in terms of the permission by right?
So permission by right within the zoning ordinance, there's really a couple different categories that are important. One is not permitted under any circumstances, and then there are permitted either with a conditional use permit or a special exception. So that is a kind of a quasi standard where you can do it where it's not fully permitted and you have to meet certain criteria. But now with the state statute, it means that ADUs are allowed universally, and the other important aspect then is that universally without subject to very modest restrictions, anything that a municipality may want to do. So there's some uniformity. So people, when you're talking to people, and if you have a client that's interested in an ADU or finding a property that has an ADU with this statute, it makes the analysis a little bit easier because you can look to the state law. The only caveat is that towns can regulate and say that the maximum limit can be 750 square feet. If they don't or if the town doesn't change their zoning to put that restriction in, it's 950 square feet. So it's a valuable tool, particularly for the affordability and access crisis that we have in the state. So it's just one more way to allow more available property and to reduce barriers to creating these accessory dwelling or maximizing someone's property. So it's a valuable tool, something you should keep in mind, particularly if you're talking with listing agents, that there may be ability to market your property as having ADU availability, whereas before that would be difficult to say because you might have to get zoning approval. Do keep in mind, however, that that's not a blank check, that the ADU still has to comply with other generally applicable zoning requirements. Those would be sort of things as, water and septic requirements and setback requirements. So it's not a blank check, but it is a great step forward in terms of freeing up properties in New Hampshire to be more fully utilized.
So just a reminder, this bill is in effect. So if somebody goes to their town hall and are told, nope, you need to approach the planning board in order to get permission, what would your advice to them be?
The advice to them was talk to your attorney, because under this statute that the town can't make you do that. I mean, they're required to give you a building permit so long as your plan that you are seeking to do complies with the setback and the water and sewer requirements and is either not in excess of 950 square feet, or if the zoning ordinance has been changed in the town, not in excess of 750 feet. But that should not be a requirement to go to the planning board to get permission for the ADU. You may now still need to go to either the planning board or the zoning board if, for example, you want a waiver from the setback requirement, or you're too close, or there's something else you may need to do. But if you meet all the other general zoning criteria, you are entitled to go get a building permit.
Great. So another new law that we've had lots of questions on has to do with the allowability, the permissibility of building on a Class 6 road. So that's Senate Bill 281. Keep in mind that that Dave's in front of my camera right now, so you can't see me. But keep in mind that a property owner had such a right and ability to do so prior to this law. Again, they just needed to go to the town to get permission to do it. This is, again, sort of switching more by right. But there are certain hurdles they're going to have to get over, right, Matt?
There are. So it does kind of clean up the process and make it, again, simpler and frankly more unified, so you're not subject to some of the vagaries or whims of local town zoning officials. With the new law, which I think goes into effect on July 1st, 2026, you can do it. You can build on a classic road, but you are required to complete a more detailed waiver form with the town, which just basically means you're acknowledging that the town is not going to provide you any services, that you're acknowledging that you're going to maintain the road, and you're waiving and releasing the town from any liability for the fact that they're not providing you any services. So if you do that and you record the waiver, you have to record it in the registry, and then you have to, before you get a building permit, and the last step is you have to show that the property is insurable, because the towns want to make sure that's satisfied. But if you can do that, then you can get a building permit to build on a Class 6 road.
Great. And lastly, we just want to talk about House Bill 60. This is relative to termination of tenancy at the expiration of a lease. Again, this bill had been in the works for 4 or 5 years now, finally got through and has been signed into law by the governor. So what does that mean for landlords and tenants?
Sure. This is a very significant change in landlord-tenant law that, as Bob noted, has been long coming. It arises out of a Supreme Court decision that is probably 10 to 15 years ago, which said that under the landlord-tenant statute, where you can evict someone for non-payment of rent, but otherwise you evict them for good cause, and the statute had a whole bunch of criteria. And the Supreme Court interpreted good cause and basically said the mere expiration of a lease is not good cause. So the fact that you had a tenant sign up for a year lease and then you wanted to get rid of them after the year lease, that alone, the statute didn't allow you to do that. So that's met with, property managers and commercial landlords in particular, very much did not like that and felt that was inconsistent with the freedom of contract in New Hampshire. And so this legislature has been passed. And so now it allows you, as long as you follow the statute, there's a 60-day notice requirement that when the lease is up, you can evict the tenant if they don't voluntarily leave. And now it is good cause. The expiration of the lease agreement you were in is good cause. So it does make it simpler and frankly more consistent with the lease now in New Hampshire to be able to remove a tenant if the lease expires and for whatever reason the landlord does not want to renew the lease for that tenant.
And it's important to keep in mind that this bill does not go into effect until next July. So July 1st of 2026. And the reason for that, the legislature wanted to give tenants a year heads up that this was coming. So if someone had signed a lease on July 1st when this went into effect. So again, it will not be going into effect until next year. So that's sort of an update. Again, the new laws booklet's on the front page of NHR's website. If you want to get a hard copy, just shoot me an email and we can put that in the mail to you. And with that, I'll kick it back to Susan.
Wonderful. Thank you very much for all that information. We wanted to talk about the exempt listing disclosure addendum. This addendum is required by NAR and Prime MLS. Our New Hampshire Forms Subcommittee worked on creating something that would be helpful for Prime to meet that obligation. And I want to pass it over to Matt to give us more information about this addendum and the policies thereof.
Sure. So thank you, Susan. So this is the genesis of this was NAR's new policy to offer a variety of choices to the membership. But part of that policy requires that for sellers to agree to either either marketing it fully off or the delayed marketing option. You have to have the sellers have to sign a disclosure indicating that they understand what benefits they're giving up by going forward with that. So it'll flow through Prime MLS, but as the Realtors Association, we felt it was our duty to come up with a form or a template. Like all our forms, this is a template form that can be used that we make available to all members. It doesn't have to be used. If you have a brokerage that wants to do a different form or try a different way, that's up to you. But this is one that is available if you have those situations where you have a seller where it's in their best interest and they want to avail themselves of one of these other marketing opportunities. It's there to be used. It's probably used relatively infrequently, but it's there and available if necessary.
Great. It looks like we have a hand raised. Jen, is that related to the exempt listing disclosure addendum?
I think she may have had a question earlier.
Oh, question earlier. Sorry if I missed you, Jen.
That's okay. Hold on. Okay, can you guys hear me okay?
Yes, we can.
Okay. Sorry, I'm in my car here. So I just want to go back to that House Bill 60. I know that you have the you have a 60-day notice to notify tenant, but then there's also a 6-month file processary action. I don't know what that really means. That's the secondary portion to that. Can you talk about that? Thank you.
Sure. So what that means is so you have to give 60 days notice, and then within 6 months, you have to actually, and when I say you, I mean the property manager or landlord, you have to take the affirmative step of bringing a eviction action in court. And how that works in New Hampshire is so you give them the notice, that's the 60 days you did at the front end, but then you have to file a landlord tenant action in the district court where the property that has jurisdiction over the property or location where the property is to actually get a writ of possession to evict the tenant. So they basically are trying to say, you can avail yourself of this approach, but then you can't leave the tenant. You can't just have it in limbo. Like if you really want them out, you then have to take the steps to get them out. So that's what that means.
Okay, thank you. Thanks for the question too. Now on to forewarn. Okay, so that's our we have forewarn. It's provided at the NHAR website. There's a bright red banner across the top that you can click and access Forewarn. For those of you who aren't aware of it, it's an excellent tool to help us. It's a tool we can use towards the land fraud issues, one of the tools that we have great access to. It's a realtor benefit for us at NHAR. They also may be some of the, I think Vermont and Maine may also provide it as well. But if you do not have it, please go on to the NHAR website, download it, utilize it. It's a great tool to use. You enter an individual's phone number that may be reached out to you just to verify some of the basic information for safety also. So I highly encourage you to do that, to also encourage the members within your office to do that as well if they haven't.
And can I just make a risk
Please.
management tip on that as well? I have not seen it, and I'm not suggesting we will ever get there, but the power of that program, and in particular with land fraud and deed fraud on the rise and very difficult, it's really incumbent to for brokers and agents to take reasonable steps to try to protect themselves and their clients from this event happening. And Forewarn is really one of those steps. And so I encourage you strongly to use it, take advantage of it, and be able to use the checking system it has to do a little bit of due diligence. And at some point in time, if you haven't used Forewarn or you don't do anything similar to that, someone could call into question whether you were taking appropriate steps to make sure and protect yourself and your clients in this scenario. So this is an easy one. I would encourage everybody to take advantage of it fully, because it's also protective if there's ever a claim later on about what did you do to guard against this event happening.
And it's provided by your NHAR benefit. So please do sign up if you haven't. Thank you for that, Matt.
I think you have one more question again.
Oh, one more question.
Or maybe the hand didn't put down.
Jen, did you put your hand down before?
No. This is to that. So, to this, do we or have we talked about any kind of future plans that if someone is misrepresenting themselves as an individual, that between realtors, there's some spot where we can at least report it and at least signal. So at least for, it comes up a lot in land fraud, at least identifying, okay, this property keeps on getting targeted, or this individual saying that they're so-and-so keeps on saying that they're whoever they are, just so that we're all aware, because they will jump from realtor to realtor. And so I just didn't know if I know there's some liabilities there, but I think it might be something that should be discussed, or maybe has been vetted. I just, wanted to make comment on that.
Matt?
Yeah, that's a great question. So I completely appreciate the sentiment, and I know they do jump around. The challenge from an organizational structure, or even from a realtor broker structure, is once you sort of assume the mantle of that you're going to have this list or you're going to track it, then you're unfortunately burdened with making sure you get it right, or else you end up with some exposure. So there's a danger of basically trying to say, hey, we have the list, and this person's not on the list, or we're going to maintain the list. So it's a good idea. It's just risky and difficult to implement in practice. That's all.
Okay. Thank you, and thanks for the question. Ralph Valentine? You're muted, Ralph. Okay.
Here I am, sorry.
Okay.
On this forewarned, so I don't use it, and here's my concern, and maybe Matt, you can address it. So I get a call, or I see a number, either way, and I do this forewarn, or I get a call and I talk to this person, then I check forewarn, and then something comes up. How am I addressing it with that person? What am I saying? The reason for me not to do business, not to show the property, not to call them back? Is there liability? I'm not using it.
I can't see a liability scenario where someone calls you for services, solicits you, and you decide not to take it, and you don't have a listing agreement, you've signed no contract with them. They have no legal right to make you do realtor brokerage work for them. So It's really just as a clearing and a vetting tool for you. And so you can vet it. And if you get a response that makes you uncomfortable, then the answer is you can tell them anything or you can tell them nothing. They're not entitled to know a reason why that you don't want to work with them. You're a independent contractor. You own your own business. You're free to work with whomever you want or not want, so long as you don't run in, as long as there's not a Fair Housing Act implication over how you're picking and choosing. But I don't think you're not obligated to tell them anything if you don't want to, or you could just say, hey, look, I'm going to take a pass, or I'm too busy to be able to meet your needs. You can come up with lots of different reasons.
Okay, thanks, Matt. We have another question, Heather Peterson.
All right. Yes, I have a question about the exempt listing addendum. The form is called the office exclusive addendum, and yet all the language in the form says the firm who owns the listing, the firm has decided. So why is the form called an office exclusive instead of a firm exclusive document?
I don't know the full answer to that. What I can tell you is that we used firm because firm is the shorthand or the abbreviation we use for brokerages throughout most of our documents. So we wanted to be consistent. But I know people think of the terminology generally as like an office exclusive. So that may be the title there for purposes of just making people understand and be able to find it on zip forms easier. That may have been the reason, but it doesn't have a legal significance one way or the other.
Yeah. Firm is what is the legal significance, correct?
Correct.
Thank you.
Because firm encompasses more than just you can be a solo person and you can be working individually, you can be working a larger brokerage, and so we want a term that encompasses everything.
Thank you. Yes, that's what I understood, but I wanted to clarify.
Good question.
Thank you. Bob, I'm going to pass this over to you regarding NHAR committee signups.
Sure. Just real quick. Wanted to take a moment to invite you as well as your agents to participate in our committee structure here at NHAR. We have sent out a couple of emails inviting members to sign up for 2026 committees. That information is also on our website. If you went to About Us and then down to Committees and then Core Committees, you can sign up directly through our website as well. Obviously, we can't, whether or not it's public policy and all the work we're doing at the legislature or with legal committee and everything that's being done with risk management, as well as our forms, we can't operate without the input and the cooperation of members. So we would invite you to participate. We do try to keep as much as we possibly can whenever possible. Meetings on remote or on Zoom. It's not always possible. Sometimes we do have to get together, but we are also certainly aware of the time constraints that everyone has and how busy they are. But we would invite you to participate in our committee structure next year if you so choose. Back to you, Susan.
Okay, great. Reminders about the NHAR monthly education series. It's held the first Thursday of every month, 3 CE credits via Zoom. The next session offers negotiation for buyer clients with Monica McGillicuddy, which is next Thursday. So just wanted to make sure everybody puts on their calendar the first Thursday of every month. You'll have free 3 credit CEs. So be sure to sign up for those as you can. Lastly, I just want to thank Dee Jurius for being here today, for Matt, Bob's, everybody here at NHAR. Thank you for providing this for the brokers. I want to encourage everybody to stay involved at NHAR, check out the resources, use Forewarn, really utilize your member benefit. Hopefully we'll see you all back here for the Winter Broker Forum. This is a great opportunity for everybody to stay plugged in. Thank you very much for being here.
Thanks, everybody.
Thanks, everybody.